हाँ चालू करिए.
Yes, sir.
सोनाली बहन.
Yes, sir. Hello, good morning to everyone on the e-platform of Faculty of Law GLS University on the occasion of the Virtual Judgment Writing Competition 24-25. I extend a warm welcome to the esteemed guest for the event, Honorable Mr. Justice M.R. Shah, former Judge, Supreme Court of India. I heartily welcome Dr. Mayuri Pandya, Dean, Faculty of Law, GLS University, all the faculty members, participants, students, and all the viewers who have joined us as an audience on the e-platform of Faculty of Law, GLS University. Before we begin this event, with gratitude in our heart, let us take a moment for a prayer.
कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः शत्रुबुद्धिविनाशाय दीपज्योतिर्नमोऽस्तुते दीपज्योतिर्नमोऽस्तुते शुभं कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः
Truly said that a judge's duty is to deliver justice. The work of judiciary is foundational to a just society. Judges are the guardians of fairness, entrusted to uphold the law and ensure that every individual will get what they deserve. Through careful judgments, impartialities, and wisdom, the judiciary preserves order and ensures that justice is not only done but also seen to be done. In a society governed by law, the judiciary must stand as a mediator between law and morality, ensuring the equilibrium of equity and equality tempered by reason and compassion. Socrates described justice as requiring a courteous hearing, wise deliberation, thoughtful consideration, and impartial judgment writing. Considering the importance of the judgment writing skill, today we have gathered here on the e-platform of the keynote and with the keynote speaker, Honorable Mr. Justice M.R. Shah, former Judge, Supreme Court of India, on just judicial eloquence, the art and science of writing judgments, and the result declaration of virtual judgment writing competition 24-25. Now, I would like to invite the backbone and the powerhouse of Faculty of Law, GLS University, our Dean, Dr. Mayuri Pandya, for her welcome address. Ma'am, over to you.
Thank you, Senani. Ya Devi Sarvabhuteshu Shakti Rupaya Samskrita. Namastashe, 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 Namo Namah. I bow down to Vidya Shakti, present in one and all who are present over here on our e-platform of Faculty of Law, GLS University. On behalf of GLS University, Faculty of Law, I heartily welcome Honorable Mr. Justice M.R. Shah, former Judge, Supreme Court of India, for accepting our invitation and for the declaration of the result and for addressing all the budding lawyers across the country. This virtual judgment writing competition, I welcome all the participants who have joined today across the country with us, and all the participants who participated to appraise Honorable Mr. Justice M.R. Shah sir across the country country, many national law universities and the law colleges have participated across the country in this event. And many students, enthusiastically, all the young budding lawyers have taken keen interest in the judgment writing. Of course, the judgment writing is a very later part of the career, because right now they are all the budding lawyers studying in law colleges across the country. So I appreciate all of you for participating in this event, and I welcome each and everyone who have joined today for this event. This is for all the budding lawyers for you, that today our keynote speaker is so important person, and a human being, a very humble, and a person who has contributed a lot to uphold the spirit of the Constitution of India. To his credit, 712 judgments who has written his judgments, 712. So a very appropriate person for today to address you on the judgment writing skills. I once again heartily welcome you, sir, on this e-platform, and thank you so much for accepting our invitation. And only one last thing which I would like to add here is this is for everyone who has joined today. Mr. Justice Emma Shah sir is our bright alumnus of GLS, so we are always proud of her. And this is his commitment to his alma mater, that even going to and getting to this heights to the Supreme Court also, he is very humble and he is always with us. Sir, I welcome you once again, and I welcome all the media people, everyone who has joined on this e-platform of all the students, all the faculty members. But I welcome each and everyone who has joined. Thank you very much. Thank you. Over to Senani.
Thank you so much, ma'am, for such a warm welcome. Now, I would like to invite Ms. Neha Burani, Assistant Professor, Faculty of Law, GLS University, and the coordinator for the Virtual Judgment Writing Competition 24-25, to formally introduce chief guest for today. Ma'am, over to you.
We are honored to welcome Honorable Mr. Justice M.R. Shah, former Judge of Supreme Court of India, as the keynote speaker and the special guest for today's event. Sir embarked on his legal career in 1982, practicing extensively in the Gujarat High Court across diverse fields, including civil, criminal, constitutional, taxation, labor, and corporate laws. Over the years, he has gained prominence as additional standing counsel for the central government and retainer counsel for CBI, representing key institutions such as municipalities, panchayats, and educational bodies. In 2004, Sir was elevated as an additional judge of Gujarat High Court, becoming a permanent judge in 2005. His judicial journey continued as he was appointed the Chief Justice of Patna High Court in 2018. Later, Sir was appointed as the Judge of Supreme Court of India in 2018. Sir is a distinguished jurist renowned for his sharp legal acumen, eloquent judgments, and commitment to upholding justice. His insights into judicial history and legal reasoning continue to guide aspiring legal professionals and scholars. We are privileged to have you deliver a special lecture on judicial eloquence, the art and science of judgment writing, and look forward to your invaluable wisdom.
Thank you so much, ma'am. Now, I would warmly invite the guest for today's event, Honorable Mr. Justice M.R. Shah, former Judge, Supreme Court of India, to share his expertise and wisdom on the art of judgment writing with all the participants, students, viewers who have joined us on the e-platform. Sir, we are honored to have you with us. Over to you, sir.
Very good morning to all of you. a dynamic Dean Mayuriben Pandya, Dean GLS Faculty of Law, GLS University, other faculty members, dear students, dear participants, and all who are at present the part of this virtual judgment writing conference. First of all, I am thankful to Mayuri Ben for your all good words about me. I do not know whether I deserve it or not, but thank you very much, Mayuri Ben, for your kind words. Thank you very much for the to the university, more particularly Faculty of Law, for giving me this opportunity to say a few words on the judgment writing, which is a very important stage in the justice delivery system and judicial process. Thank you very much for giving me this opportunity and to be part of the family of the GLS University. Judgment writing is an art, and I am thankful and I congratulate the university and the faculty members and Mayuri Ben for choosing this very important topic, which may help those who would like to join the litigation or who would like to join the judiciary. As said, the final destination or the final stage in the judicial process after concluding the hearing of the suit or the writ petition or even the trial is the judgment. Those who come to the court, who are compelled to come to the court because of the circumstances, are eagerly waiting for the D-Day, that is the judgment day and the judgment. So, a great care and caution to be taken while delivering the judgment, dictating the judgment, and what to say in the judgment. As said that judgment is justice is not to be done, but it is seen to be done also, which can be reflected from the judgment itself. Now, first of all, let us consider the language of the judgment. I am not talking about the language means Gujarati, English, or vernacular English, vernacular language, or whatever it may be. I am talking about the language of the judgment. Language of the judgment, according to me, must be very simple. Judges, while dictating the judgment, are not supposed to write the essay. They are also not supposed to use any flowering words or flowering language. It should be as simple as it is, so that a common man may understand the language of the judgment and what is written in the judgment. See, most of the litigants are common men. They are coming from a village or a town. All litigants are not corporates, or they do not have the facility of their own battery of lawyers who can tell them what is written in the judgment. Therefore, the judgment must be simple and it should be very precise. Now, next stage would be when you start dictating the judgment. My only request is that by and large, no judgment should be kept pending for a long time. Otherwise, you will forget what is argued, what was the matter, what was the substance of the matter, and ultimately the finding. So, as far as possible, please deliver the judgment at the earliest so that you can remember everything that what is argued and it must be reflected in the judgment. Now, the next stage would be initiation or starting of the judgment. Don't start dictating the judgment without any preparation. First of all, you must understand and know the dispute in the matter and the facts in the matter. Thereafter, the law point, and thereafter, appreciation of evidence. So, without even you start the dictating the judgment, it will not be a precise judgment like as it should be. It should be in the sequence which I'll tell you here and after. So prepare yourself and thereafter make a note, correct, and thereafter start dictating the judgment. Now, so far as the substance of the judgment is concerned, first of all, it must reflect the proper application of mind by the judge who is the author of the judgment. First paragraph would be, suppose it is a repetition, then first the paragraph should be that this is a petition under Article 226, 227 of the Constitution of India, in which 1, 2, 3, 4 is under challenge, and this is the relief. If it is a suit, in that case, in the first paragraph itself, you must state that this is a suit for declaration, this is a suit for permanent injunction, or this is a suit for partition. And the description, suppose it is a suit for partition or land dispute, whatever it may be, then you must say that this is the dispute with respect to so and so, and this is the relief sought in the suit. That should be your first paragraph, so that the appellate court can immediately know that what was the suit and what relief was sought. That must be there. It must be reflected from the first paragraph itself. Second thing, then you should start with the pleadings and the plaintiff's case, not the submissions, that this is the plaintiff's case, correct? Thereafter, the next stage would be that these are the evidence, the documentary evidence or evidence which is laid by on behalf of the plaintiff. Third paragraph, thereafter, the entire judgment should be in sequence, so that 1, 2, 3, 4, 5, 6, so that either appellate court or even the client or the litigant or even the advocate must know that first stage this, second stage this, second, third, fourth, fifth, sixth. So if it is in sequence, then it can be said to be a beautiful judgment. Then next question would be the defendant's case or respondent's case, and what is stated in the affidavit reply or what is stated in the written submission, written statement. The next stage would be that on the basis of the evidence on record, on the basis of the material on record and the pleadings in the plaint as well as in the written statement, the court has framed the following issues. Correct? So you should say the 1, 2, 3, 4, 5, 6, 7 issues. Thereafter, you should deal with the issue-wise discussion. Issue number 1, write down again that this is the issue number 1, underline it, and thereafter start giving your findings on the issue. Now, while deciding the issue, what is required to be done is you should give the finding coupled with the appreciation of evidence. That so far as this is concerned, the evidence, plaintiff's evidence is this, or petitioner has said this, defendant's evidence is this, and thereafter I find on the basis of the appreciation of evidence and the material on record, whatever document, you should discuss it, and thereafter you should give the finding. Then thereafter you write down that so far as the issue number 1 is concerned, it is held accordingly, whatever it is there, correct? and it is held in negative or in positive, correct? Or and it is held in favor of the plaintiff or the defendant. That specific finding must be there in every paragraph while deciding every issue. Now, the next stage would be that all your findings must be supported by an independent finding and the appreciation of evidence. It must be supported by the evidence on record. No findings should be given or can be given with rehearse the evidence or the evidence on record or the documents which are not exhibited. Once the documents are not exhibited, that's an end of matter. You are not required to deal with those documents. Only those documents which are exhibited and considered in the evidence and admissible in evidence, only those documents to be considered while giving the finding. All your findings must be supported by the cogent reasons and appreciation of evidence. All of you must understand that while dictating the judgment, you are supposed to, you are bound to, and you are duty bound to record the submissions made by the learned counsel appearing on behalf of the respective parties. You should not avoid anything, and it should not be a part of or the ground in the appeal before the higher forum that though I have argued this point, correct, though the evidence was laid, the trial court or the court has not dealt with the same. Similarly, whatever the judgments are cited, you must deal with it whether you like or not like, or whether it will help the plaintiff or the defendant. The court is supposed to act fairly and independently and without any fear or favor or without bias. It must be reflected in the judgment, from the judgment, that yes, the court has considered and delivered the judgment impartially and treated both plaintiff and the defendant or petitioner or the respondent fairly. Not to deal with the submissions made by the learned counsel appearing respective parties, or not to deal with the judgments which are cited can be said to be a judicial dishonesty, which must be avoided, and it should not happen at all. That is the first thing which is required to be considered. If you have the third thing will be, suppose particular judgments are cited or particular judgment is cited, and you must be aware that there is a concept of per incurium. Per incurium means the higher forum or the Supreme Court or even the High Court, if it is found that while delivering a particular judgment, the High Court has not considered the binding decision of the Supreme Court, or even the Supreme Court also, while delivering the particular judgment and taking a particular view, has not dealt with or considered the earlier decision of the Supreme Court of a coordinate bench, then you can consider it as a judgment per incurium. But it is my advice, those who would like to join the judiciary and the lower judiciary or first or second stage or below the High Court, normally they should not dare, I am using the word dare, they should not dare to declare a particular judgment per incurium. Even High Court also, as a High Court judge also, it is my humble advice to them that as far as possible, don't consider a judgment of the Supreme Court per incurium. If it is a coordinate bench, then you can write down that thus this has happened. Correct? In the particular judgment, earlier judgment has not been, it appears that it has not been dealt with or considered. Correct? But as an obedient soldier, I am bound by the Supreme Court judgment or the Appellate Court judgment, and therefore I am taking a particular view, relying upon or following this particular judgment. then let the higher court or the Supreme Court may reconsider their decision if it is your judgment is under challenge before the Supreme Court, and let the fresh view can be taken by the High Court, by the Supreme Court. So, for the trial court is concerned, it should not be that you may consider that it is a per incuriam judgment. You must bear in mind that you are not at all wiser than the High Court or the Supreme Court. Therefore, don't consider it as a per incuriam. Thereafter, after the findings are given issue-wise, correct? Thereafter, your ultimate conclusion that whether the plaintiff or the petitioner is entitled to the particular reliefs or not. Now, so far as the reliefs are concerned, there must be a clarity, full clarity, that the common man must know that what relief he has got and what relief he has not got. A common man, the litigant before the court, has a right to know that for what he has come to the court and for the what relief has been given by the court to him. If there is a clarity in the judgment, in the operative portion of the order, it may avoid the further litigation at the stage of execution. See, it is said that the second litigation in our country, unfortunately, the second litigation starts when the decree is passed and it is at the stage of execution. One should avoid that there is a confusion, and there can be two views which may ultimately lead the controversy before the executing court. If whatever the relief you have given is 1 + 1 = 2 and everybody has understood, correct, then there may not be any further complication or the dispute with respect to interpretation of the reliefs granted before the executing court. Therefore, the operative portion of the order must be very clear and it must be unambiguous and must give the clarity of thoughts and clarity of the relief which is given. Don't give the relief half-heartedly. If it is half-heartedly given, correct, or there is a chance of misinterpreting that, correct, you should avoid it. Otherwise, your judgment ultimately will be vulnerable even before the higher court. One advice to you, that while delivering the judgment, the only and only consideration should be the merits of the case and nothing further than that. You should not worry about what will happen if you write a particular judgment or take a particular view, then what will happen to the appellate court. You should not worry about that. If your judgment is challenged before the appellate court, then what will happen? The moment matter is over, the moment you deliver the judgment, you should forget that matter. Don't change your matter. Don't change your judgment that yes, my judgment is confirmed or my judgment is reversed. Correct? If you consider then it can be said two things. That either you are over ambitious or you have a personal interest in the matter. As a judge, impartial judge, you should not have any personal interest in the matter. Therefore, don't change your judgment that my judgment is set aside or my judgment is reversed or my judgment is modified. You should not worry about the same. It can happen to the High Court judgment also, that whatever you say, even as a trial court judge, sometimes the High Court reverses it. Correct? In that case also the Supreme Court again reverses the High Court judgment. Correct? And restores the trial court judgment many a times. Therefore, you should not worry about the judgment, your judgment, the future of your judgment. That is the second thing. So, by the writ petition is concerned, suppose you join the High Court and you become the High Court judge. So, far the writ petition is concerned, you must precisely in the first paragraph itself say whether it is a petition under Article 226 or under Article 227. The reason is that if it is under Article 226, then the latest patent appeal will be maintainable against the single judge judgment. If it is 227, it may not be maintainable. But if it is mixed, 226 and 227, then the latest patent appeal will be maintainable. Many times the questions before the appellate court are have arisen that whether the latest patent appeal or the appeal would be maintainable or not. To avoid that, you must say that this is a petition article so and so and so and so, and whatever you say in the judgment in paragraph 1 will be considered appropriately by the appellate court. And appellate court can say that as the trial court or the court has considered, or the high court as the single judge has considered the writ petition article 226, then certainly the latest patent appeal would be maintained. Second stage in the writ petition would be what is the petitioner's case? What is the relief sought in the present writ petition? You can say that by this petition under Article so and so of the Constitution of India, the petitioner has prayed for the following reliefs. Correct? Then you should write out the reliefs which are sought, or whatever the order of the government or whatever authority it is under challenge, or trial court's order is under challenge, you should stay, so that the appellate court can immediately at the first sight can know that what was under challenge before the learned single judge, or what was there in the writ petition. Thereafter, the petitioner's case. Thereafter, after petitioner's case is narrated, then the affidavit reply, the respondent's case, the reply filed on behalf of the respondent, and thereafter, only thereafter, your own finding on appreciation of the submissions made before you by the counsel on behalf of the petitioner and counsel on behalf of the respondent. Here again, caution that you should deal with all the submissions made, and you should deal with all the judgments which are cited. You can very well say that this is the repetition. You can very well say that, I suppose there are 100 judgments are cited. It is very easy to get 100 judgments on Supreme Court cases online, or AIR, or other GLR, GLH digital. You give the click particular word and you will get 100 judgments. On that, whatever word, 100 judgments will be there. It was not there when I started the practice or in earlier days. We were required to consider each and every volume and for the purpose of finding out the judgment. That was the labor which was being done at the relevant time. But it is anyway, technology has made everything easy. You can get, but ultimately, if latest judgment has considered all other judgments, correct? You can write down that yes, he has cited the judgment, correct? But all these judgments have been dealt with in the recent decision, and you can deal with the recent decision in which all other earlier judgments have been dealt with and considered, and thereafter you give your finding. You are not required to repeat all the judgments, correct, and make the judgment very bulky. As I said, your judgment should be precise, simple, which can be understood by the client, a common man, and the litigant. While delivering the judgment, you must bear in mind that you are always dealing with a litigant who is a common man and who doesn't know the intricity of the law. He must know, correct, that my submission, my case has been properly understood by the court. And thereafter, whatever the decision you take, correct, but it should be from the judgment itself, it should reflect that here is a judge who has understood my case and who has properly appreciated my submissions, correct. Thereafter, you give the final relief, again giving the precise relief, what is granted, what is not granted, so that it can avoid the contempt proceedings in future if it is a repetition, correct, or at the time of execution. So all these things are required to be taken care of while delivering the judgment. Suppose it is a criminal trial or it is a criminal appeal before the High Court. If it is a criminal trial, then first of all, you must deal with or write down the prosecution case. That what is the prosecution case? What is stated in the FIR? Thereafter, the case is committed to the trial court for the then charge was framed. After the charge was framed, the case was committed to the trial court or sessions court if it is 302 murder or a very serious offense above 7 years, and the case is triable by the sessions court. Then you should write that the case is transferred or transferred to the sessions court, committed to the sessions court, and thereafter one by one you should deal with the prosecution witness evidence. Thereafter, the if at all, then 313 statement of accused. Thereafter, the case on behalf of the defense. If the defense witness have been examined, you should appreciate and or consider the defense witness, and thereafter you should one by one give the finding that whether he is guilty or not. If it is found to be guilty, give a specific finding that he is held guilty for the offense under section so and so of the so and so, and thereafter, after he is held guilty, correct, he is acquitted, then there is no difficulty. If he is held guilty, then you know that you are supposed to hear the accused so far as the sentence is concerned. You consider the submissions made on behalf of the accused, that these are the mitigating circumstances, and therefore always accused will say that a lesser punishment should be there. But at the same time, while punishing a person or imposing the sentence, you must ultimately consider the interest of the society at large. If it is very serious offense under the POSCO Act or a murder with rape or whatever it may be, very serious offense or economic offenses, correct? You should appropriately sentence a person, and you must specifically mention, suppose there are 2, 3, 4 offenses committed. In that case, you can say that he is held guilty for the offense under so and so. He is sentenced to undergo 3 years RI. Specifically, you should say whether it is 3 years RI or 3 years SI. RI means rigorous imprisonment and SI means simple imprisonment. If suppose thereafter for another offense he has been convicted in the same trial, correct, then also give the specific punishment that he is held and sentenced to undergo so and so, so and so. And ultimately, you should say that all the sentences should be undergone concurrently or consecutively, so that in future there is no problem. Suppose you are awarding the life sentence. In that case, the life sentence you can say that life until death or life 14 years. Normally it is 14 years, 16 years, 20 years. But that depends upon the gravity of the offense. So like this, everything must be there. Suppose it's a bulky matter, even civil matter also, in the writ petition also, or you find that it is a very important matter in the form of a question of law, correct, or a bulky, then you insist upon the written submission. If so that not that you can consider the same ditto or copy paste it, so that you may not miss any submissions made on behalf of the parties. It must be. Second thing, while delivering the judgment, it must not reflect from the judgment that you have copy pasted it either from the written statement, written submission, or even from the plain. Your independent application of mind is must while delivering the judgment, deciding the matter and delivering the judgment. Therefore, avoid copy pasting the pleadings either in the plain or in the written statement. Correct? Thereafter, leave it to the court, leave it to the higher forum. Your job is over. And one another thing, as I've stated, don't keep the matter or the judgment pending for a long time. So far as I am concerned, I may share my experience. that whichever the bulky matter or biggest matter having 800, 900, 1000 pages, correct? I have never kept any judgment pending for more than 1 week, even Supreme Court. And when the big matter is concerned, you should start dictating something. Suppose today some arguments are made, correct? In the evening, you write down that, correct? Give the dictation, keep it ready, so that ultimately when you are going to deliver, dictate the judgment, it will help you, correct, in dealing with all the submissions. As again, I am telling you, deal with all the submissions made before you. Deal with all the judgments which were cited before you. And uh, I firmly believe that not dealing with the same, either deliberately or without deliberation, correct? Without any intention, it will it can be said to be a judicial dishonesty which must be avoided. In my entire career, I am telling you that nobody has said in the ground of appeal before the higher form that this point was argued, correct, or this judgment were cited, but the same has not been dealt with. Why should we not deal with the same? It is unless you have got a personal interest and you believe that this judgment will help a particular party, then this particular view can be taken. Don't do it. That is my humble request and advice to all of you. Don't change your judgment. uh, uh, Ultimately, you may be right. And appellate court, it is said that even Supreme Court also sometimes, correct? Supreme Court is right because it is final. If there is an appeal before against the Supreme Court judgment, then also, correct, it can be set aside or subsequently they are reviewed also. You should not worry about the same. Do it impartially, correct? Simplest language must be used while dictating the judgment so that people can understand. Uh, Anything else, it's a very lengthy subject. It's a really an art and if you use this seriatim and the style, plaintiff's case, defendant's case, evidence, appreciation of evidence, issues, findings on issues supported by the reasons, correct? All stated that all your findings must be supported by the reasons, and there should not be any dishonesty at all. I may give you one example. One appeal from order against the injunction order of the trial court came before me as a high court judge. First paragraph, something was stated. Then after, immediately next paragraph was, for the reasons stated herein below, I hold so. After then next one paragraph, and thereafter what is stated herein above, I hold so. In between there was nothing, no reasoning, no finding, nothing. The reasoning ढूंढते रह जाओगे. That should not be reflected. That should not be there. That so it should every submissions, correct, and must be or finding must be recorded along with the appreciation of evidence. Mayur Ben, thank you very much for giving me this opportunity. And again, you call me on whatever subject. If I know, I'll definitely join and now the university. Thank you very much. And once again, sorry, congratulations to all who have participated. I'm saying who have participated, because those who don't play the game, correct, there is no success. If you sit idly, correct, then there is no subject. There is no success. Only a person who participates or plays the game, correct, then and then there are all possibilities of succeeding. Congratulations to all who are going to win the position of 1, 2, or 3 today, which will be declared after some time. Thank you. I wish you all the best. And it is my wish that good people must join the judiciary. And I am sure that GLS University will prepare the students and so that they can join the judiciary, and more people, students of the GLS University may join the judiciary. Thank you very much. Namaskar. Jai Hind, Jai Jai Garvi Gujarat.
Thank you so much, sir, for such an enlightening session. You rightly said that don't chase your judgment. It depends on the interpretation. Impartial judgment are very important. You guided us with every small point to be considered in a judgment writing. So you nicely explained the advancement of electronic assistance for referring the judgment. Rightly said by you that the judgment should be precise and in a simple language rather than bulky and ambiguous language. Thank you so much, sir. With
My,
your permission, shall
my
we
pleasure.
take a few questions from the students and the participants?
Yes.
Sure, sir. Sir, first question is given increasing reliance on the artificial intelligence for legal research and drafting, do you foresee technology influencing the future of judgment writing? And how should the judiciary adapt to maintain its human touch in an ethical way?
Very, very, very good question. And very hot topic is there. Uh, so far as the drafting is concerned, and so far the research is concerned, I think there should not be any difficulty so far as the AI is concerned. It may give you the draft also, and we are getting the draft also, even in contract drafting also, even in pleadings also, petition is also. But so far as the judgment writing is concerned, I have my own doubt. It can help you, but it may not substitute, and it should not substitute because ultimately everything depends upon that. There are many discretionary orders. When there is a discretion to be used, correct, that AI will not help you. It is only your own thinking. It varies from person to person. It varies from judge to judge. I may give you an example. That so far as the MACT is concerned, motor accident claim tribunal is concerned. Suppose there is a formula. Hmm? It can AI can help you that this is the accident. It has happened. This is the who was the negligent, and on the basis of the evidence on record and the income of the deceased, the family members, number of the family members, dependents, correct? All this, there is a structured formula. There AI can help you. But ultimately, suppose in a criminal trial, there is an application of mind. Application of mind is there in the AI when it is used also. But there is a discretion to avoid the sentence. Suppose it is 3 years or 6 years. Suppose it is life imprisonment or life imprisonment till the death or till so and so years. AI will not help you. There you have to apply your mind. So to that extent, while judgment delivering, AI may not be able to help you. Yes,
Uh,
next question.
Sir, next question. In cases where moral considerations and legal principles seems to conflict, how should a judge decide the weight to be given to each judgment while crafting the actual order?
See, so far as the morality is concerned, uh, we are a country where law follows, and we have to go by the law. We have to go by the uh, substance or the evidence on record. You should not go by or weigh by the morality alone. Morality will help you at the time of granting the final relief. But when you reach up to the final relief, correct, morality has no consideration. You should go by the evidence or the material on record only. Hmm? One and morality, you see, varies from person to person and judge to judge, but the facts will remain the same. So one has to go by the evidence on record and whether and legal evidence. You see, you may not frame or a person yours the evidence solely on the ground of morality. Hmm. Yes, you are not. We are not able
Sir,
to
there's
hear you.
one last question, if you allow, sir, from a student from fifth year. Uh, Sir, how do you address situations where there are competing precedents or gaps in the law while ensuring that the judgment sets a clear and consistent standard for the future or
नेहा जी आप श्रील हो गई.
Sir, am I audible?
Now audible, yes.
Yes, sir. So the question is with regard to the gaps that are there in the precedents. So how should judiciary make sure that
Sir, I think there is some technical issue at Neha's end. I think we can look
No,
into
I
that.
got the point. I am having the answer also to that also. I got your point, what you are saying. You see, there is no question of gap between the precedents. Precedent is precedent, correct? You should follow even the latest judgment or old one also. Many a times it is said that 1968 judgment is a very good judgment. Justice P.N. Yogari's judgment at the relevant time, having a good vision, it is good law today also. So it is not important the gap between the two decisions or precedents. You have to follow it. As a subordinate court, even as a high court, correct? As a obedient soldier, I was always using the word obedient soldier. High court judge is an obedient soldier. Correct? He has to obey and follow the Supreme Court judgment. Unless on the face of it, it is found to be per inquiry. So there is nothing like gap between the two precedents. Huh? Okay. Yes, Payuben.
Uh, Thank you so much, sir, for sharing your. I'm sure today's lecture would have enriched them with the
Sir, I think I'm really sorry. I think there is some technical issue. I request you to please announce the result of this virtual judgment writing competition.
So first I should declare second runner-up or the winner.
Sir, third first, and then second, and then the first one.
So let there be some curiosity also. So congratulations to all participants and congratulations to the persons or the team who is going to succeed. The second runner-up is having the unique ID VJWC01 and the affiliated university is National University of Study and Research in Law, Ranchi. Congratulations, the team. Now, the first runner-up is unique ID VJWC35, Gita Institute of Law, Panipat, Delhi, NCR. Congratulations. And the winner is unique ID VJWC09, Faculty of Law, Allahabad University. Congratulations. ऐसा नहीं है कि कुंभ की वजह से अल्लाहाबाद को फायदा हुआ. For the blessings. Anyway, all the best and God bless you.
Now, I would like to invite Dr. Grishma Bhavsar, Assistant Professor, Faculty of Law, GLS University, and the co-coordinator for the virtual judgment writing competition 24-25 for the official vote of thanks. Ma'am, over to you.
Now, what do you mean by official vote of thanks? You should not thank me at all. Officially or unofficially. मैं बताऊं. This is my family. JL is always I have considered to be my family and close to my heart. So please don't have this formality or official or unofficial thanks.
Thank you so much, sir.
Complete your formality.
Good morning, everyone. With the conclusion of this virtual judgment writing competition 2024-2025, I am delighted to extend a vote of thanks on behalf of Faculty of Law, GLS University. At the outset, I express our sincere gratitude to Honorable Mr. Justice M.R. Shah, former Judge, Supreme Court of India, for sparing his valuable time to grace this occasion with his esteemed presence and sharing his profound insights on judicial eloquence, the art and science of writing judgments. His thought provoking address has not only enriched our understanding of intricacies of judicial writing, but has also cultivated a deeper sense of responsibility and dedication in our aspiring legal minds. Sir, your words will undoubtedly leave a lasting impact on all of us. We also extend our deepest appreciation to Honorable Mr. Justice B.N. Mehta, former Judge, High Court of Gujarat, for his invaluable contribution in meticulously evaluating the judgments submitted by the participants. His expertise and keen analysis have added immense value to this competition. I extend my heartfelt gratitude to Dr. Mayuri Pandya, Dean, Faculty of Law, GLS University, for her unwavering support, visionary leadership, and commitment to fostering the critical legal discourse. Her guidance continues to inspire and shape every endeavor of our institute. I also extend my sincere appreciation to our faculty members and the administrative staff for their dedication and seamless coordination in ensuring the smooth execution of this event. To our participants, your engagement with this year's thought-provoking theme, Fundamental Rights under Indian Constitution, has been truly commendable. Your ability to balance the legal principles with societal realities demonstrates exceptional legal acumen. My heartfelt congratulations to all the winners for their well earned achievement. Finally, my heartfelt gratitude to our viewers whose attentiveness and engagement have made this event even more meaningful. Your presence reinforces the importance of such initiatives in shaping the future of legal thought and practice. Once again, my sincere appreciation to everyone who contributed to the success of this event. Thank you so much.